has the final say over the production, manufacture, supply and regulation of industrial alcohol? The centre or the states? This question has been debated in the Supreme Court for over a decade. Now, the court has ruled that the centre does not have the authority to regulate industrial alcohol and states' rights to legislate on it cannot be taken away. Portable alcohol is a subject under the state list, that is, under the 7th schedule of the Constitution of India. However, industrial alcohol falls entirely under the union list. This means only the union government has control over the production of industrial alcohol. The centre and various states have been tussling over who should have the legislative rights over each type of alcohol. Industrial alcohol, also known as denatured alcohol, is intentionally made unfit for human consumption. However, it can be altered and misused, making it fit for consumption in some cases. States like Kerala, Maharashtra, Punjab and Uttar Pradesh, where the case originally arose, argued that they should have control over industrial alcohol to safeguard their citizens. The centre, however, has opposed this stance. The case took so long because industrial alcohol falls into a complicated grey area of the Constitution where multiple laws overlap. Take entry 52 of the union list. It allows the centre to regulate industries that Parliament finds to be of public interest under Section 18G of the Industries Development and Regulation Act 1951. However, entry 33 of the concurrent list allows both the state and union governments to make laws concerning products from any industry, even if Parliament has granted control to the union for reasons of public interest. This is the first overlap. Meanwhile, entry 8 in the state list under the 7th schedule of the Constitution gives states the power to legislate on the manufacture, possession, transport, purchase and sales of intoxicating liquors. This creates another overlap in authority. Now, the key term, intoxicating liquors, played a crucial role in the current judgment. In the 9-judge ruling, 8 of the judges agreed that this includes industrial alcohol. The court clarified that intoxicating liquor should not be narrowly defined as only alcohol fit for human consumption. Instead, it covers any liquid containing alcohol that could be used or misused for consumption, bringing industrial alcohol under this definition. In fact, that has been at the centre of the states' argument. They say that as the custodians of the health of citizens, they should be allowed to impose regulations on industrial alcohol and levy fees to ensure that it's not abused. After all, when huge tragedies take place, it's that state government that is expected to act. The Uttar Pradesh and West Bengal governments have been very vocal about this issue. The centre's argument was that the development and regulation of a number of important industries, the activities of which affect the country as a whole, have to be under central control. For instance, during the COVID pandemic, the centre could utilize its regulatory power to ensure the availability of ethanol to produce hand sanitizers. However, the Supreme Court gave its verdict in favour of the states. Excise, liquor and spirit have been part of the state's jurisdiction. Now, industrial alcohol joins the list.